look at 370 itself, it's a flexible article. It says that modifications can be done to ensure that the Constitution of India, as applicable to the state of J&K, should assimilate whatever is applicable in other parts of the country.
Your lordships have looked at those 4 judgments under 370.
Yes.
Well, I need to bring something to your lordship's notice in those judgments. Only what is relevant for my purpose. My lord, all those judgments, in my view, postulate the continued existence of 371. And the judgments clearly establish that notwithstanding the cessation of the Constituent Assembly, 370 would operate. And my lord, there's a reason why it must operate. If the Jammu and Kashmir Constitution, my lord, has to operate, 370, my lord, has to be in existence. The application of the provisions of the Indian Constitution can happen only through 370. And because it has happened through 370, my lord, 370 cannot be used to self-destruct. It cannot be used to modify or amend itself. This, my lord, is established in the judgments itself of your lordships, which I'll presently point out. The second is, in Sampat Prakash, there is, my lord, an express statement which is supported by legislative record that the Constituent Assembly did not abrogate but insisted on the continuance of Article 370. If that is so, my lord, I submit that Sampat Prakash takes the position that 370 is there to stay. And my lord, there is another important aspect. Why is it that the J&K Constitution was not taken note of by an express constitutional provision? The answer to that also is as follows, my lord. The power to amend the J&K Constitution, being a constitution created by a Constituent Assembly, can only lie with the body which has been created by that constitution. That, my lord, is settled law. That if a constituent body or a constituent power prescribes a constitution and elects a body under that constitution, the power to amend that constitution will lie with that body. So the body, my lord, which is competent, I'm so sorry, my lord.
But Subramanian, on that there may be a slight issue for the simple reason. One, when we read the earlier part of 1954 order, it was quite clear that the Indian Constitution has been adopted with the omissions and modifications. We may call it a J&K Constitution. It may have been referred to as J&K Constitution, but what is adopted is the Indian Constitution with exceptions and modifications. One. Number two, Article 370 by very nature is very flexible. It's flexible. And normally constitutions are flexible in time and space because they are made once, but they last for a long time. Yes, we have the basic structure doctrine, and that argument of yours that basic structure is there. But if you look at 370 itself, it's a flexible article. It says that modifications can be done to ensure that the Constitution of India, as applicable to the state of J&K, should assimilate whatever is applicable in other parts of the country.
My lord, with respect, I think I have to give, my lord, an absolutely candid answer. My reading, my lord, of the Article 370 in the light of the structure of Article 370, 1, 2, and 3, my lord, orders may be issued under 371, but they have to be based on bilateralism. And that bilateralism is necessarily to involve what is agreed upon by the state or in turn the legislature. Sans the state, sans the legislature, I submit, my lord, it will be it will not be consistent with constitutional principles to interpret 370 as if it can be done unilaterally. Well, the choice is as follows. Can the power be exercised under Article 370 unilaterally? My answer is no. The second, your lordship said it is a constitutional power. I completely agree. Third, but my lord, asymmetric federalism by its very definition means special provisions for special places or states. Like my lord, you have provisions in the constitution.
That is basically is bilateralism and federalism, which is inbuilt in 370. If it is violated, then that flexibility is taken away. That
yes, then becomes ultra vires, my lord. Then it becomes ultra vires 370. I'm very obliged for putting that question to me. My lord, I can't. So federalism and supremacy of the constitution are, my lord, conjoint principles. Both supremacy and federalism. And if both of them are injected or infused, my lord, necessarily in 370, then we have to see whether the exercise of the power under 370 can be destructive of those principles. That is the point, my lord, in this case. And there is a crucial point, my lord, which we must consider. The Jammu and Kashmir constitution, my lord, can be overturned, repealed by that legislature. But it cannot be abrogated by us. My lord, that constitution is also a document. It is also a document which is a legal document. It is both a normative document and a prescriptive document that has constituted, my lord, the legislature. The organs of the state have been constituted under that constitution. It is, my lord, entitled to be noticed. That constitution, my lord, cannot be wished away or abrogated unless the power to override that constitution can be located somewhere. My lord, this is the point here, that without there being an express provision in the constitution to override the Jammu and Kashmir constitution, my lord, what your lordships will see in CO 273 cannot happen. CO 273, if your lordship sees now with me, my lord, it abrogates a constitution. And that, my lord, cannot be done at all. Please just look at, my lord, for a moment, the document.
Mr. Subramanian.
Yes, I'm so sorry, my lord.
No, Mr. Sibal's own argument was that as the orders were issued from time to time, very little remained inside 370. Actually, that was his argument, that very little remained inside 370. So, do we have any examples where, when these COs were issued, there were any negative comment on it from the assemblies or any of the situations?
My lord, that is what I'm submitting. All the COs, which your lordships will notice, some were issued, my lord, before the dissolution of the Constituent Assembly of Jammu and Kashmir. It stood dissolved, my lord, on the 20...
No, I'm talking about the post-1957.
Yes. Now, post-1957, my lord, there were orders which were passed. Those orders were with the concurrence of the government. They were with the concurrence under D, the other provisions which your lordships mentioned. For instance, Article 356, I'll give your lordships as an example. Article 356, my lord, was omitted in the 1954 order. It was applied for the first time in 1965 by a constitutional order. And your lordships have seen that in Article 356, the words are in order, in accordance with the provisions of this constitution. So, my lord, it was in the constitutional order, Article 356 was applied, saying the provisions of the constitution in Article 356 will mean provisions of the Jammu and Kashmir constitution. I can show that order, my lord, just as an example. That 356 itself came much later. My lord, it is not correct to say that by virtue of 370 everything has happened. No, these exceptions and carve-outs have continued. These exceptions and carve-outs have continued from the 54 order, which is why what is today abrogated is the parent order 54 as amended from time to time. Well, that is why it is necessary to bear in mind that these adaptations were based upon bilateralism. These modifications were based on bilateralism. But one important feature which I may bring to your lordship's attention is, in Article 372, my lord, there is a proviso that the competent legislature can pass a law even after a president passes an adaptation order. That, my lord, is not existent here because the legislature under 147 cannot do anything to the provisions of the constitution as applied in Jammu and Kashmir.